So modes of acquiring ownership. The following are modes of acquiring ownership or ways to acquire ownership over a thing or a property. There are 6. First, occupation. Second, donation. Third, prescription. Fourth, intellectual creation. Fifth, testate and intestate succession. And sixth, by tradition and consequence of certain contracts, or what we know as delivery. So what is occupation? The following are requisites. The subject person or the person trying to acquire the property actually has the intention to acquire acquire ownership to such property. Gusto niyang i-acquire yung property. That's the first requisite. Because if ayaw niyang i-acquire yung property, then there's no occupation. So there's an intention on his part to acquire the property, and he has the capacity to consent. Second is that the object that he's trying to acquire must be appropriable by nature, meaning it's capable of appropriation. Third, it must be without an owner, or wala siyang knowledge na merong nagmamayari ng object that he's trying to acquire. And lastly, there must be an act of taking possession of the thing. When you say taking possession, it's not necessary that there is a material holding of the thing, so long as the thing is considered to be subjected to the disposition of such person or possessor. Ownership of land cannot be acquired by occupation. For wild animals, they may be acquired by occupation, but they can only be possessed or acquired by occupation while they are under a person's control. For domesticated animals naman, these are animals that retain the habit of returning to the premises of their owner. So if it happens na merong prior owner, and then there's this second person who is trying to acquire the domesticated animals, dapat hindi niya alam na may prior owner, because one of the requisites of occupation is that dapat walang owner. And if napunta sa property niya yung domesticated animal, hindi na bumalik doon sa original owner, and walang knowledge yung may-ari ng, for example, property kung saan napunta yung domesticated animals, then kanya na yung domesticated animals. However, the prior owner, if merong prior owner, has 20 days, okay, within 20 days from the occupation of another person to reclaim the domesticated animals. Pwede niyang bawiin, pero meron siyang 20 days. The reckoning point is the 20 days will start from the time when another person has occupied the property or the domesticated animals in this case. So for swarm of bees, the prior owner has the right to pursue them to another's land. But such prior owner is liable for damages that the other person may suffer. Other persons may occupy or retain the swarm of bees na napupunta sa property nila if the prior owner did not pursue the swarm of bees, or nag-start siyang mag-pursue sa swarm of bees but stopped, so ceased to pursue such swarm within 2 consecutive days from movement toward another person's property. So if hindi pinursue ng prior owner, then nag-move yung swarm of bees sa property ng another, so the swarm of bees by occupation pwedeng maging pwedeng maging owned by the person who owns the property kung saan nag-move yung swarm of bees. Birds and fishes belong to the owner of the breeding place into which they have moved, except when it belongs to a prior owner. But the movement of such birds and fishes kailangan hindi through some artifice or fraudulent means. Meaning walang in-employ na fraudulent methods yung may-ari ng property kung saan nag-move yung birds and fishes. Like, nagkusa yung birds and fishes mag-move sa property niya. So, by occupation, yung may-ari ng property, yun na rin yung may-ari ng birds and fishes. Abandoned movables may be acquired as long as the abandonment made by the prior possessor is voluntary and intentional. So, meron siyang movables, could be anything, personal property, pinabayaan na niya. Tapos, inacquire ng another person. So, gusto niyang i-acquire, yung first requisite, may capacity siya to consent. Yung bagay could be appropriated. Hindi nga alam na may prior owner. And if meron mang prior owner, kasi diba isa sa requisites without an owner, yung owner parang binigay na rin niya, hinayaan na rin niya. And dun sa part na gustong i-acquire yung movable na yon, there must be an act of taking or possession of the thing. Now, for lost movables, pag sabing lost movables, of course, there is no intention to abandon. So, it must be returned to the owner if such owner is known. If the prior possessor is known. If the prior possessor is unknown naman, the right thing to do is to deposit it with the mayor of the city or municipality where it is found. So, that's the case for movables. Iba yung abandoned movables dun sa lost movables. Sa una kasi abandoned movables, literal na hinayaan na ng owner, ayaw niya na dun sa property. So parang tinapon na niya. So if someone wants to acquire it, then pwede. Paano malalamang abandoned yung isang movable? Kasi there is no intention to retain ownership over the thing on the part of the prior owner. So voluntary and intentional sa part niya na ayaw na niya ng property niya, kaya inabandon niya. Iba naman siya sa pagbibigay or donation. Kasi sa donation, there is an intention to give it to another person. There's also this voluntariness on the part of the donor to give away his property. It's also intentional it is also the donor also has the intention to give away his property, but giving is different from abandoning. Sa abandonment, wala na siyang pake. So, lost movables naman, it's not voluntary, it's not intentional, na wala lang talaga. So, the right thing to do if it's lost is to report it to the city or municipality. You deposit it with the mayor. And what happens after depositing it with the mayor? The mayor should publicly announce the finding of the thing for 2 consecutive weeks in the way he deems best. So, pwedeng sa bulletin, pwedeng sa publication, basta dapat may announcement. If the item cannot be kept without deterioration or without expenses that considerably diminish its value, it shall be sold at public auction 8 days after the publication. If the owner does not appear within 6 months from publication and hindi pa na public auction yung item, for example, it's not the nature of the thing, hindi naman siya deteriorate and hindi naman kailangan gastusan para i-preserve yung thing, so hindi siya na-sell sa public auction, then the thing shall be awarded to the finder. If within 6 months after na publicly announced ng mayor that there's that thing deposited sa municipal hall or sa city hall, then ibibigay na lang yung thing or even the value of the thing to the finder. If the owner naman appeared in time, the owner is obliged to pay the finder 1/10 of the price of the thing. So, merong reward yung finder if binalik niya, which is 1/10 of the price of the thing or the value of the thing. Any hidden and unknown deposit of money, jewelry, or other precious objects belong to the owner of the property where it is found, given that hindi kilala kung sino yung owner ng deposit of money, jewelry, or other precious objects. Kasi kapag kilala naman kung sino yung owner, may pangalan naman doon, kailangang ibalik sa person na yun. Otherwise, it is unjust enrichment. So tradition, it's the second way of acquiring ownership over a property. This also means delivery. So there is actual delivery made when the thing sold is placed in the control and possession of the vendee or the buyer. It is not always essential to the passing of title. Parties may agree on what conditions the ownership shall pass to the buyer. There is constructive delivery naman when there is execution of public instrument, symbolic delivery, traditio longa manu, traditio brevi manu, traditio constitutum possessorium, quasi-tradition, and delivery to a common carrier. So tradition is thoroughly discussed sa sales. So pwedeng, for example, delivery of property, like delivery of real property. Pwedeng real property. How do you deliver real property? Because you cannot move it. It's an immovable. So you give the keys. The giving of the keys is a symbolic delivery, for example, or keys to a condo, for example, or pwedeng public instrument, such as transfer certificate of title for land, for delivery of land. So you can't physically deliver land, right? For personal properties naman, of course, you can physically deliver the thing. So that is actual delivery. Otherwise, it's constructive delivery. So donation. Donation is a transfer of the title of the property from the donor, the giver, to the donee, the receiver. It effectively reduces the patrimony of the donor. When you say patrimony, pagmamay-ari. Nabawasan yung property niya. Property niya yan, nirelinquish niya para sa favor ng ibang tao or benefit ng ibang tao. Which in turn, yung nakatanggap would have an increase in wealth. Si patrimony, parang wealth na din. It is not enough that the act is gratuitous. There must also be the intent to benefit the donee. So gratuitous meaning willing niyang binigay due to the goodness of his heart or generosity or benevolence. Pero hindi enough na magbibigay ka lang out of your generosity. Kailangan yung bibigay mo would actually benefit the receiver or the donee. So the requisites of a valid donation: capacity of the donor to make a donation. There must be an intent to donate or donative intent, animus donandi. There must also be delivery, which is actual or constructive delivery of the subject of the donation or the thing that is donated. And of course, acceptance by the donee. There is no valid donation if walang acceptance. Acceptance by the donee is required because donation is never obligatory. One cannot be compelled to accept or receive the generosity of another. You can always refuse a donation. Although under Article 725, donation is an act, it is really a contract. The essential requisites of consent, subject matter or object, and cause must be present. Yung kinaiba lang, for example, sa sale, is it sa sale, merong consideration, merong bayad. Sa donation, wala. And donation has a form that is prescribed by law. And you also have to pay donor's tax if it reaches a certain amount. Persons who may give or receive a donation. Sino yung may capacity to give and receive donations? Generally, all persons who may enter into a contract can be a donor or donee as the case may be. As long as they can enter into a contract, they can dispose of their property, then they can also enter into a contract of donation. But there are exceptions. Guardians and trustees cannot donate property entrusted to them. Minors and others who are incapacitated to enter into contract, they cannot by themselves become donees or donors, except they may become donees if yung acceptance is done through their parents for minors, or kung wala silang parents, then their legal representatives. Same with incapacitated persons. Their legal representatives can receive the donation on their behalf. Conceived and unborn children, they cannot be donors or donees. However, they can be donees if acceptance is made by persons who can legally represent them if they were already born, such as their parents, for example, or guardians. When the same thing is donated to two or more donees, the rule on double sales shall govern. What is the rule? If it's a movable property, then ownership goes to the first possessor in good faith. If immovable naman, the ownership goes to the first registrant in good faith. So if the same property was donated to two persons, at least two persons, two or more, if it's movable, personal property, kung sino yung unang nag-possess ng property, siya yung donee. Siya yung entitled sa property, na-acquire niya yung ownership over the property by donation. If immovable naman, kung sino yung unang nagpa-register ng property. Donation of a movable may be made orally or in writing. Ito mayroong prescribed form under the law. Pero pwedeng oral. If the value of the movable property is less than 5,000 pesos, the donation may be made orally or in writing. Pero if oral, kailangan may simultaneous delivery. Otherwise, it is void. Meaning, ibibigay mo siya, sasabihin mong ibibigay mo siya as donation, at the same time, ibibigay mo na rin yung property simultaneously. If in writing, it is valid kahit wala pang simultaneous delivery, kahit for later na lang. If the value of the movable property, however, exceeds 5,000 pesos, the donation and acceptance must both be done in writing. Otherwise, the donation is void. The donation of an immovable property or real property like lupa, bahay, real estate, it must be made in a public document, meaning notarized. The acceptance of the donation may be made in the same document or in a separate instrument. When the donation and acceptance of an immovable are in the same instrument, it must be in a public instrument and the properties donated and the charges must be specified therein. Siyempre, kailangan magbayad ng donor's tax. When the donation and acceptance are in separate instruments, the donation must be in a public instrument with the properties donated and the charges specified therein. The acceptance must be made in a public document during the lifetime of the donor, and such donor must be notified of the acceptance of the donee, and the notification must be noted in the instruments. Why? Because the donee has the right to accept or reject the donation, and the donor has the right to know of such acceptance or rejection on the part of the donee. Kasi kung na-reject yung donation, di alam niya na hindi na ibigay, pwede pa niyang i-dispose yung property niya however he wishes. If in-accept naman, alam na niya na na-relinquish na niya yung ownership of the thing and tinanggap na nung donee. Hindi na niya pwedeng ibigay sa iba or hindi na niya pwedeng i-dispose. And he loses his rights as an owner to the property because it has been transmitted to the donee already by virtue of the acceptance of the donee. Donation inter vivos takes effect during the donor's lifetime. Actual execution may be deferred until donor's death. This is made out of the donor's generosity. Execution meaning actual taking of the property. But the donation must be done within the lifetime of the donor, and the acceptance must also be done during the lifetime of the donor. Otherwise, kung hindi in-accept while the donor is alive, then that property, the donation is not considered valid and the property will form part of the estate of the donor. And if it forms part of the estate of the donor, then the heirs will be entitled to it. So it's governed by the formalities of donations, valid even if the donor survives the donee. That doesn't matter. Like for example, naunang mamatay yung donor. As long as yung donation na complete, the donation and the acceptance and the notification to the donor of the acceptance was all done while the donor is alive, then that is valid and can even be executed after the donor has already passed. It cannot be revoked except for grounds provided by law such as inofficiousness and ingratitude. So inofficious meaning excessive and already encroaches dun sa presumptive legitimacy of the compulsory heirs by virtue of our laws on wills and succession. Because under our laws, the compulsory heirs are really entitled to a portion of the estate of the deceased. So if dinonate yung property and kulang na yung share ng heirs dun sa estate ng deceased, then pwedeng i-revoke yung donation kasi priority yung legitimes ng compulsory heirs. So right to dispose of the property donated is conveyed upon the donation and it is subject to donor's tax. Donation mortis causa takes effect upon the donor's death, or this is made in contemplation of the donor's death. It is void if the donor survives the donee. Kasi hindi siya, yung donation mangyayari lang after nang mamatay ng donor. So pag nauna namatay yung donor, wala na kasi wala na yung donee. I mean, kung mauna pa lang mamatay yung donee, yung bibigyan, wala na kasi nauna nang namatay yung donor. Kasi nga, magiging effective yung donation after mamatay yung donor. So, kung naunang mamatay yung bibigyan, by the time na namatay na yung donor, wala na yung receiver, wala na yung donee. It is governed by the formalities for the validity of a will, may only be accepted after the donor's death. But on the part of the donor, pwede niyang i-revoke, pwede siyang mag-change ng mind niya before siyang mamatay kasi hindi pa naman effective until mamatay siya. So, it's still his property until then. The right to dispose of the property is retained by the donor during his lifetime and instead of subjecting it to donor's tax, it's subject to estate tax. Pero yung treatment sa kanya is like a will. Donation propter nuptias made by reason of marriage and before celebration of which for the spouses. So, this is thoroughly discussed sa family code. So, if hindi matuloy yung marriage, then pwedeng ibalik yung donation because the reason why the donation was made is in consideration of marriage. So, if it doesn't transpire, nawala yung consideration. Because again, donation is also a contract. Simple donation is in consideration of the liberality of the donor based on the donee's merits. Remuneratory donation given an account of the services provided by the donee to the donor which do not constitute a demandable debt. So, for example, someone is ill and a stranger took care of that person. The caretaker is, for example, the sick person donated property to the caretaker, then that is considered as remuneratory donation. Hindi yan sahod, but sort of a thank you for the services rendered by the caretaker. So that's an example of remuneratory donation. Modal donation imposes a burden on the donee or the receiver which is less than the value of the gift, meaning hindi pa rin siya, okay lang, donation pa rin siya. Kasi mas may benefit pa rin yung receiver although merong burden. Like for example, merong babayaran like siya yung mag-shoulder ng donor's tax. But the value of the property received is so much more. So that is still considered as gratuitous. Onerous donation, where the value of the donated property exceeds the value of the thing it is given for. It is governed by the laws and obligations and contracts. The patrimony or assets of the donor is decreased to the donee, while that of the donee is increased in effect. Limitations, reservation of sufficient means for support of donors and relatives. Donation without reservation is not null and void in its entirety. It is only subject to reduction by the court. Limitation applies to simple, remunerative, and modal donations, but not to onerous ones nor to donations mortis causa. Donations cannot comprehend future property. What are future properties? These are properties that are not owned by the donor at the time of making the donation. Anything which the donor cannot impose of at the time of the donation. The reason is that nobody can dispose of that which does not belong to him, and even sa future inheritance, it cannot be donated because it is considered future property. It's also possible that an heir, for example, a supposed heir like a child, will die before the parent, for example. So in that case, hindi siya entitled sa inheritance kasi nauna siyang mamatay. However, upon the death of his predecessor, the inheritance ceases to be future and consequently may be the object of donation. So for example, if saka na namatay, then hindi na siya considered future property, yung future inheritance. But until then, you can't dispose of future inheritance because the reckoning point for that is the death of the decedent. Amount of donation is limited to what the donor may give by will. A person may not donate more than he can give by will. A donation which exceeds what the donor may give or receive by will is considered inofficious. Limitation applies where the donor has forced or compulsory heirs, as discussed earlier. There is reduction when there is total withdrawal of amount, whether the legitim is impaired or not, and this benefits the donor. Revocation is only for the amount insofar as the legitim is prejudiced. This benefits the donor's heirs, except when made on the ground of the appearance of a child. Revocation due to birth, appearance, or adoption of a child applies only to donations inter vivos and not to donations mortis causa, honors donations, and donations propter nuptias. So for example, a person was not aware that he or she has a child, so that child is entitled to a portion of the estate as a compulsory heir. So hindi pwedeng lahat i-donate. So if lahat na donate na, and dahil sa donation, nawala na ng share yung isang child, then some donations may be revoked in favor of the heir or the child. When you say pure donation, it's not subject to a condition or period. Conditional donation is subject to a condition, with the term subject to a resolutory or suspensive term. So that's for donations. So now let's talk about prescription. So prescription is a mode wherein one acquires the ownership and other real rights through the lapse of time, in the manner and under the conditions laid down by law. In the same way, rights and conditions may be lost by prescription. So through lapse of time, you can lose your property or you can acquire property. That's prescription. So for purposes of acquiring ownership, only acquisitive prescription is being referred to. Persons who are capable of acquiring property or rights by the other legal modes may acquire the same by means of prescription. Minors and other incapacitated persons may acquire property or rights personally or through their parents, guardians, or legal representatives. Offender can never acquire through prescription movable properties possessed through a crime, such as robbery, theft, or estafa. When the plaintiff is in possession of the property, the action to quiet title does not prescribe. The reason is that the owner of the property or right may wait until his possession is disturbed or his title is assailed before taking steps to vindicate his right. The action or defense for the declaration of the inexistence of a contract does not prescribe. No prescription shall run in favor of a co-owner or co-heir against his co-owners or co-heirs so long as he expressly or impliedly recognizes the co-ownership. Prescription, both acquisitive when you acquire property through the lapse of time or extinctive when you lose property through the lapse of time, does not run against the state in the exercise of its sovereign function to protect its interest except with respect to its patrimonial property, which may be the object of prescription. Actions for reconveyance based on fraud prescribes 4 years from the discovery of fraud. Actions for reconveyance based on implied or constructive trust prescribes in 10 years from the alleged fraudulent registration or date of issuance of certificate of title over the property. So, acquisitive prescription, when you acquire ownership over the property through the lapse of time, the acquisition of ownership and other real rights through possession, and the concept of ownership of a thing in the manner and condition provided by law. We have ordinary acquisitive prescription and extraordinary acquisitive prescription. When you say ordinary acquisitive prescription, it requires possession of things in good faith and with just title for the time fixed by law. Ownership and other real rights over immovable property are acquired by ordinary prescription through possession of 10 years. Extraordinary acquisitive prescription is the acquisition of ownership and other real rights without the need of title or of good faith or any other condition. So usually 30 years. Extinctive prescription. It is the loss or extinguishment of property rights or actions through the possession by another of a thing for the period provided by law, or through failure to bring the necessary action to enforce one's right within the period fixed by law. Requisites are: first, capacity to acquire by prescription; second, the things capable of acquisition by prescription; third, possession of the thing under certain conditions and lapse of time provided by law, whether 10 years or 3 years or 4 years or 8 years. So for movables, 4 years if in good faith, and 8 years if in bad faith. So to recover movables, action prescribes 8 years from the time possession was lost, unless the action is brought after 4 years when the possessor has already acquired title by ordinary acquisitive prescription. So pag lapse ng 4 years, kanina yung property. Pero if good faith, lapse ng 8 years, kanya na yung property even if bad faith. Immovables, 10 years, kanya na yung property if possessed in good faith, 30 years if in bad faith. So to recover immovables, real actions prescribed after 30 years except if the possessor acquired ownership of the immovable by ordinary acquisitive prescription through possession of 10 years. So in a way, parang occupation din. So laches. It is considered with the effect of delay and not the fact of delay, which is prescription. It is principally a question of inequity of permitting a claim to be enforced. This inequity being founded on some subsequent change in the condition or the relation of the parties. It is not statutory and it applies at equity, and being a defense of equity, it need not be specifically pleaded. It's not based on a fixed time. So dapat yung, for example, 4 years in possession in good faith or 8 years in possession in bad faith of movables, for you to acquire property through that, dapat uninterrupted, yung 4 years or 8 years. Same with immovables, 10 years if possessed in good faith, 30 years if in bad faith, dapat uninterrupted. Parang considered nyo siyang abandoned if pinabayaan na ng owner. So, when is there interruption? There's interruption when the action is filed before the court, or when there is a written extrajudicial demand by the creditors, or when there is any written acknowledgement of the debt by the debtor. An interruption of the prescriptive period wipes out the period that has elapsed, sets the same running anew, and creates a fresh period for filing of an action marireset. If there is an interruption, all the benefits acquired so far from the possession ceases. So for example, land. You're in possession of land for 28 years na. So 2 years na lang magiging sa'yo na yung property. Kahit bad faith pa yan. However, the owner of the property now demanded that you leave the property. Filed an action sa court or merong extrajudicial demand for you to leave the property or ibalik na yung property sa kanya. So yung 28 years mo na yon na-interrupt, hindi umabot sa 30 years, kahit 2 years na lang. So once na tumigil yung demand, for example, or wala namang nangyari, wala na, interrupted na, may fresh period, you have to start over, back to zero ka. Kailangan mo naman ng another 30 years of uninterrupted possession of the property. Natural interruption is when a natural cause interrupts the possession for more than 1 year. There is civil interruption for acquisitive prescription from the time judicial summons are received. There is civil interruption for extinctive prescription from the time action is filed in court. Written extrajudicial demand by the creditors is received, or when there is written acknowledgement of the debt by the debtor. The period of interruption shall be counted in favor of prescription. As if interruption never happened, it is merely suspended if judicial summon is void, plaintiff desists from the complaint or allows the proceedings to lapse, or the possessor is absolved from the complaint.